Okay, and then now let's talk about roles within the wills and trusts and estates. And what I mean by that is another point of confusion. Again, it's just around verbiage, and I think people know it, but they still kind of get tripped up over it. Is the executor and the trustee. So if you want to kind of high level, what are those two, and how do they play in?
Yeah. So, and actually, it's funny. Executor, I think, also comes from TV, movies, or something, or just, we hear about executors. Hawaii law does not use the term executor.
Okay.
So, the person in charge of your trust is the trustee. So, when you set it up, like if I've set up my trust, there's three parties to a trust. There's the settlor or the grantor, person putting the funds in, setting it up. The trustee, person managing whatever's in the trust, and the beneficiary.
Mm.
And so when for my trust, I am the settlor, I am the trustee, and I'm the beneficiary. When I become incapacitated, I'm still always going to be the settlor, but I've named someone else, my sister, to be my successor trustee. And while I'm incapacitated, I'm still the beneficiary. But if I pass away, my son is now the beneficiary. So the
Mm.
trustee and the beneficiary can change. Settlor is always going to stay the same. And all of that's within a trust. Who
Right.
sets it up? Who's managing it? Who's getting the stuff from it? Those are the parts of a trust. Executor would be the person in charge of the will. So Hawaii law calls that a personal representative.
Okay.
Personal representative is a lot harder to throw around than executor. And if you really like personal representative, they're representing a person, like it's confusing, but
Mhm.
that's what Hawaii law calls it. So we all in the legal field, we just shorten it to the PR. So the
Gotcha.
personal representative is usually the same person as the trustee when you set up the plan, because the question is who's going to be able, capable, reliable, trustworthy to handle things for you from the financial side if you can't, whether you're incapacitated or you've passed away. That
Mm.
person is usually going to be the trustee or the successor trustee, the personal representative, the power of attorney, sort of those three roles.
Mm.
And that's how we refer to them. Which role they're in depends on what asset they're dealing with, usually.
Gotcha. And I think depending on the complexity, these aren't these aren't the easiest roles to be appointed to, right? As a trustee, I think some people might think I want to be the trustee because I want to be in charge
Yeah,
without really understanding. Well, it could be a lot of work and a lot of responsibility, right?
it is. Like I don't think people realize, especially like in an instance where you've got three kids, in three siblings who are in a family, and mom and dad pass away, and the oldest one is the trustee, and the middle one is the one who lived here and took care of mom and dad. And they're like, how come I'm not the trustee? I want to be the trustee.
Right,
And
right.
I know everything that's going on. Da, da, da. And it's like, you know what? If you're the beneficiary, usually in that situation, we got three kids as a beneficiary, one of them's a trustee. These two over here are still going to get their share.
Right,
They
right.
don't have to do anything. They get to sit back and wait. So the waiting part is difficult for a lot of people. It's control, it's access, it's
Mhm.
information. But, going back to what you said, it's a job. And it can take years depending on the assets, depending on the complexity. I mean, it can take years, and in those years, it's hours and hours and hours
Mm.
of your life that just weigh on you. You have to file tax returns. You have to contact all these companies. You have to respond to any inquiries. You have to deal with the lawyers. You have to deal with the
Mhm.
accountants. So it's a lot of work. And so there are clients I've had who come in and they're like, I'm nominated as a trustee. My younger brother is an accountant, an attorney, he's more type A than me. Do I have to do it? Can I let him do
Mhm.
it?
Mhm.
So there's a lot of people who will pass it up because they see the writing on the wall and they don't want to do it because it is a lot of work. You have legal responsibilities, you have fiduciary
Sure.
obligations. I mean, it's no joke.
So they can though, right? Can they pass it on to, let's say they want to pass it on to a brother, or is there other means where they could just seek out somebody like you and say, "Hey, listen, I'm an electrician. I'm a little in over my head. Can you just, you know, I
Point
don't
you in the right direction. Yeah.
right, 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 right.
Yeah. So Depending on what the trust says, usually, typically, uh, a person named as trustee, the electrician says, I don't want to do this, but if I can just get a little help, I think I can.
Right.
They could definitely, trustees can hire professionals to help, attorneys, accountants, etc. But even they could delegate it to another person
Mm.
for a specific time, for a specific asset. They're still, at the end of the day, they are the trustee, but they're delegating some responsibility to someone else to handle some part of it for them. That's usually allowed. It's allowed under the law, but it can be limited by the terms in the trust. The trust could say, nope, I'm naming Stacy as my trustee because I trust her. I don't want anybody else touching this, So in that case, no, the person would have to handle everything on their own. If there is a person named as a backup, for sure, I tell people if you're good with the next person in line, or if there is a next person in line and you don't want to do it, by all means, you can decline to serve as trustee.
Gotcha. And then, so the personal representative, I guess we'll get into the next part is probate, and if you don't have these documents, and then so there is an instance when the court can appoint somebody as personal representative if there's nobody named, right? Or no, or let's say that person is no longer alive or whatever it might be, right?
Yeah, so for personal representatives, it's always going to be a court appointment because it's a will, and a will has to go through probate before someone is authorized to do anything. So classic situation, there was a bank account that that either they didn't get in the trust, or they named a beneficiary, but they only named their spouse as beneficiary. Spouse died before them. It was a joint account. Now both spouses have passed away. And now what do we do with this account? If it's over 100,000, so Hawaii has a threshold of 100,000 before there's a probate, and it's when you add everything up together. So if there's an account here with 25, an account here with 50, an account here with 25, you've hit your 100. It's not 100 at each institution. But once it's going through probate, if there's a will, you look at who's nominated as personal representative, and the court will say, okay, person A, where's person A? If they've passed away, you have to provide a death certificate. If they don't want to do it, they have to sign something that gets filed with the court that says, I don't want to do it. Sometimes it's maybe if it's an older will, parents named their friend or their sibling to serve. And the sibling, it can get complicated. The sibling could live on the mainland and now is incapacitated. So they can't sign something that says they don't want to do it. What do we do? So you just kind of have to show the court why person A is not involved, and the court you might have to do an affidavit, you might have to get a doctor's note. There's a lot of different things. But we get to, let's say there's person A isn't available, person B isn't available, and there's no person C. So now what do we do? Whoever the heirs are or the beneficiaries are typically have to get together and pick someone, nominate someone. So that's where you can have fights. Let's say it's that situation. Mom and dad had a will from a long time ago when their kids were small. They named their siblings. The siblings have passed away. So now we're at the kids, and there's two kids and they both want to do it. And now we're in court, so it just becomes then a fight for who's going to do it, or do they get court appointed to serve together and share the responsibility? Lots of different outcomes. If there's no will, the law provides who has priority to serve. And so there's a list. It's if there's a surviving spouse or reciprocal beneficiary, or trying to think if that's like first. Then there's heirs. So if it's was there a surviving spouse? If not, then it's usually the kids. Again, it gets complicated if you've got blended families, second marriages. Are there kids from the spouse, from a prior relationship? It's a web when you really start looking at the law. It just depends on the complexity of the family dynamic. But essentially, yes, there is an order of priority, and the court will look to that and say, okay, who's first? And again, you can have people with equal priority, and it depends on who wants to step up, who wants to do it. if they both want to do it, if there's more than one person that wants to do it, that's what gets settled in the court proceeding.
Interesting. And then, so I'm trying to think back to my CFP estate planning courses here, and I can't remember. So if you have, so what you just mentioned, we're talking about wills. Let's say you have a trust and you only named one person as the trustee and they passed away and you never updated it. Is it the same type of thing?
Same type of thing. Usually the trust will say, I name this person as trustee. If they're gone and there are no successors named, then typically it's a majority of the beneficiaries get to appoint someone.
Okay.
Gets complicated where what if the settlor is still alive? They've named their spouse as trustee, but the spouse has passed away and there is nobody else named. Now what do we do? Because there's the only beneficiary is still that incapacitated settlor, but who gets to nominate a successor trustee? And the answer to that is it depends and it gets complicated. Sometimes right. The agent under a power of attorney can nominate. But again, if they only named one successor trustee, that's probably also the person they named in their power of attorney. So you might hit a dead end there. You might need a court appointment of a conservator for that person, which is a whole nother thing. You might need there are court proceedings for trusts. So we've only kind of talked about probate, as a court proceeding, but you can have a trust proceeding in court where you maybe whoever's wanting to step up, maybe it's a kid, maybe it's a friend, maybe it's a beneficiary who's going to get it when that person passes away. They can go to court and say, here's the situation. We got a settlor. We don't have a backup trustee. We don't have anyone under the trust terms who's able to nominate. Or who's able to, say who's going to be trustee. So here I am in court asking the court to review everything and I'm suggesting I be the person. And so the court will look at everything, notify anybody who might be affected, like the other beneficiaries for after that settlor passes away. This is why proper planning can avoid all these, wow, I never thought it could get this complicated. And
right.
Yes, let's try to avoid it.
Gotcha. And it's a good reason to name, because you can name contingent trustees, and it's good to kind of not stop with just one person, right?
Definitely good to do. Definitely name as many as you want, as many as you can, as long as, and so I have people ask me that too. They're like, how many do I need? I'm like, there's no number, because you also may have 5 kids and none of them are capable of doing it, so you don't want to just name them because they're your kids. You want to name someone who's trustworthy or responsible, good at communicating, going to be able to handle everything. So there's no magic number, but I tell people when they're setting up their plan, I advise my clients, however many deep you can go, the better, because you never know, what might happen.
The opinions and statements presented on this show are for general information only and are not intended to provide specific advice or recommendations. Never make any investment or financial decisions based on information offered on this show without first consulting your financial, legal, or tax advisor. All economic and performance information mentioned on the show is historical in nature and is not indicative of any future results. All indices mentioned on this show are unmanaged and cannot be invested in directly. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy. Lastly, all opinions expressed by Jason Cutitta and any guests on the show are solely their own opinions and do not reflect the opinions of or are endorsed by ToBA Financial. For Jason Cutitta, investment advisory services are offered through ToBA Financial LLC, a registered investment advisor offering advisory services in the state of Hawaii and in other jurisdictions where exempt from registration.